May I please, my lord? My lord, I beg to mention two items to have a fixed date, my lord. One is CRP 25 of 2024 and one is FAO 3 of 2024. Both are connected case. This matter was supposed to be listed after 2 weeks. 2 weeks has been already completed, but yet it has not been listed, my lord.
When do you want?
For September 2, 2nd September.
September 2?
Yes, yes. Okay. Bless. May I? My lordship, I beg to mention unlisted matter. In the last occasion, as per order, adjournment was taken after for 2 weeks. The time has been over, and moreover, my senior counsel, he's coming from Guwahati, S. Datta, so he'll be able to make on 27th.
What is the matter?
It's a criminal petition regarding this thing. Criminal petition 10 of 2024.
No, you make prayer before registry. Registry will fix the. There is a direction to fix it after 2 weeks.
Yes,
Judicial
actually,
direction is there.
actually, my lordship, the senior counsel has specifically asked me to take that particular date because he have another matter in nearby district. So on that day, he can, appear both the cases. It will be convenient for him since he's coming all the way from Guwahati.
Okay.
Okay, deeply obliged.
Lordship, I beg to mention for withdrawing item number 6, matter become infraction.
Heard Mr. Gautam Fukan,
Yes.
learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application as it has become infructuous. Considering the submissions made by learned counsel, the prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
Lordship, I beg to mention item number 3.
3.
Yes. In this, we have to file reply. So 3 weeks time maybe.
Heard Mr. S. Yiran,
Yes.
learned counsel for the petitioner. You have informed the other side.
Yes. We have informed the other side.
Why you are seeking adjournment?
Lordship, we have to file reply.
Who prays for some time for filing reply to the objection filed by the respondent side. The prayer is allowed. Let this matter be listed after
3 weeks, Lordship.
3 weeks.
Yes. And Lordship, interim is there.
2 weeks. The interim order shall continue.
And Lordship, item number 15.
Item number
15.
15.
15 and 16, Lordship.
What is the prayer?
Yes, with the consent of the other party, this matter may be taken up after 2 weeks, Lordship.
Huh?
This may be taken up after 2 weeks. We have taken the consent from the other party.
Other party is the PP only.
Yes.
Yes. Heard Mr. S. Yiran, learned counsel for the appellant. Why you are seeking adjournment?
Lordship, the leading counsel is out of station. L permit.
Who prays for an adjournment on the ground that Mr. L. Pirme, learned conducting counsel for the appellant, is out of station. Considering the grounds mentioned by the appellant, learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
I knew last.
Your Lordship, I beg to mention item number 19. I am appearing on behalf of Diki
19.
19.
Yes.
I am appearing on behalf of Diki Pangin. He is leading counsel out of station.
Heard, Miss. You have informed the petitioner side.
Yes.
I'm going to petitioner, my lord. My lord, here kindly fix that may be given. My humble request, my lord.
Heard, Mr. What is your name?
C. Taju.
Learned counsel for the petitioner who prays for an adjournment on the
Lord,
ground.
counsel for the respondent.
counsel for the respondent who prays for an adjournment on the ground that Mr. Dicky Panging, learned counsel representing the respondent, is out of station.
My lord, can I have a fixed date?
Also, Mr. What is your name?
M. Khambo.
M. Khambo, learned counsel for the petitioner
Yes.
who does not opposes the prayer.
My lord, can it be on August 29?
No. Next week.
Your lordship, after 2 weeks. 2 weeks.
No, he want a fixed date. You suggested it.
August 29.
No, apart from August.
Apart from the 10th September.
Let the matter be listed again on 10th of September.
Okay. Much obliged.
I beg to mention item number 5.
5,
Yes,
yes.
this is the leading counsel is out of station due to some medical.
What is your name?
K. Dagyam.
K.
Dagyam.
Dagyum,
Yes.
learned counsel for, who is the conducting counsel?
L. Kurdu.
Learned counsel for the petitioner who prays for an adjournment on the ground that Mr. L. Kurdu, learned counsel for the petitioner, is out of station. Considering the grounds mentioned by the petitioner, the prayer is allowed. Let this matter be listed after a week on a
1
date,
week. Yes. 1 week.
after a week on a date to be fixed by registry.
Lordship, I would like to mention item number 14.
1/4,
Yes, Your
yes, what is your prayer?
Lordship, I'm on behalf of the conducting counsel, Mr. Teto Taba. Lordship, the conducting counsel is absent due to demise of his father. So the
Heard
matter
Miss
W. Jena.
W. Jena, learned counsel for the petitioner, who submits that the conducting counsel, Mr.
T. Taba.
Teto Taba, is in bereavement and therefore prays for an adjournment. The prayer is allowed, considering the ground mentioned by the petitioner, considering the ground mentioned by learned counsel. Let this matter be listed after a week on a date to be fixed by registry.
Obliged, sir.
Your lordship, I beg to mention item number 18
1/8,
as a, yes. As the conducting counsel is out of station, and we have taken the consent from the other side to be fixed the date on August 29.
Mr. Sonar,
Yes,
heard Mr. What's your name?
BVI.
Learned counsel for the petitioner who prays for an adjournment on the ground that Mr. R. Sonar, conducting counsel for the petitioner, is out of station. Considering the ground, the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Much obliged.
Lordship, I beg to mention item number 4.
4,
Yes, for the petitioner side, on the behalf of A.K. Prokasto, due to his some health issue, he can appear today.
you have
So-
informed the other side.
Yes, I've
I'm
already.
I'm for the state, your lordship. Private respondents are there.
Private respondents, you have informed.
Yes, we are already informed that given that consent.
Heard Miss
Dirilung.
Learned counsel for the petitioner who submits that due to personal difficulty of Mr. A.K. Purkas, the learned conducting counsel for the petitioner, an adjournment is prayed for. Also heard Mr. T. Ete, learned additional public prosecutor, who does not opposes the prayer. The counsel for the petitioner submits that she has also informed the counsel for the private respondents. Considering above, the prayer is allowed. Let this matter be listed
Lordship, matter may be listed on 9th.
on 9th of September 2000.
Yes.
Oblige, your lordship.
Yeah, Lordship, I beg to mention item number 2. The leading counsel is out of station due to sudden demise of his father-in-law, Mr. Elbam.
Heard Mr. What is your name?
B type, Lordship.
B.
B
Type-
type.
Typodia. Learned counsel for the petitioner who prays for an adjournment on the ground that Mr. L. Bam, who is the conducting counsel, for the petitioner is in bereavement. Considering the ground the prayer is allowed, let this matter be listed
2 weeks, Lordship.
after 2 weeks on a date to be fixed by registry.
Obliged, Lordship.
Oh, 28.
Item number 1.
Yes,
Yes, Lordship,
392.
yes, Lordship, 341, 392, and
What is 392?
punishment for robbery.
Robbery.
On the basis of the mutual settlement, which is the application of paper. So this is a very old case of 2006 Lordship. May I take Lordship to page number?
No, Mr. Ete, whether in case of robbery, such petitions may be allowed.
Your Lordship, first of all, whether the ingredients are there, that has to be prima facie look into. And second is, Your Lordship, the classification of offense, whether it fall under the offense, under heinous offense or not, that has to be looked into. Your Lordship, I will come to that.
Let us see.
Yes.
Yes, make your submission.
Lordship, may kindly come to page number 21, Lordship, which is the type copy of the FIR.
Yes.
I am to inform you that today in front of Akashi at about 14:30 hours, while I had parked my Bolero new vehicle and gone down to call my brother, one Nagram Ragam gave me one blow and snatches away the vehicle key. Among his group, numbering about eight pelted stone on the standing vehicle and ran away. I do not know them by name, but can identify them. This was the allegation.
He was
taken. away.
He was taken.
He was taken.
In fact, that day, a bun call was called by Itanagar Youth Association.
Huh?
A bun call was, yes,
Oh,
a
okay.
bun call was given by Itanagar Youth Association. And during that bun call,
Who gave the Bandh call? Itanagar
Youth Association,
Youth Association. Okay.
this incident of 2006. So during that bun call, Lordship, this complainant came to the market area wherein this group of around 8 to 10 people were gathered.
2006, when the charge sheet was filed.
So it was filed in the year of 2006 itself. Year number is also of 2006. So during that incident happened during that month or all. But that he was returned to the owner just after some time.
2008 charge sheet was filed.
There were about 8 to 10 people, but only this kills were started. Otherwise, the rest of the people are compounded.
At what stage the trial is pending now?
It is pending at the stage of CCO, consideration of charge.
Charges are not yet framed.
Not yet framed.
Now, who has compromised?
So see, this between the complainant and the accused. Petitioner number 1 is the complainant.
Where is the settlement? What has been, what is the settlement between the parties?
In the passage of time, this victim and the accused person has become relative. Kindly, come to page number 42. This is the
You use microphone.
Lordship, may kindly come to page number 42, Lordship. This is the deed of settlement, Lordship. Deed of mutual settlement. The Lordship may kindly see the para number 2, Lordship. that now, Lordship, both the parties, the first party and the second parties, are close relatives. As the first party had married to the younger sister of the second party, as such, he don't want to proceed.
His brother-in-law.
Yes, Lordship. With the passage of time, they become relatives. Now, therefore, the chance of conviction is very blank, Lordship.
Earlier, you were not knowing that you were brother-in-law.
No, that time they were like unknown to each other. So,
Later on, this
yes,
relation.
in the year of, I was told by the petitioner that in the year of 2012 or 13, Lordship, they become relatives. Lordship. During that incident, they were unknown to each other.
Stage of consideration of charge. Offense of robbery is concerned, so far as the classification of the offense is concerned, it will fall under serious offense, not heinous offense, Your Lordship. Why I'm submitting, Your Lordship? Because in the CRPC or even in the new code, Your Lordship, the classification has not been given to what offenses will be considered to be the heinous one and what will be the serious one. But in JJB Act, Your Lordship, it is provided. And basing on that, the Honorable Supreme Court has held that the offenses which punishment is not minimum punishment should be 7 years, and then it goes to any extent, then it will be considered as a heinous one. But if it is below and it is above 7 years also, it will fall under the category of serious offense, Your Lordship. And now the second aspect here is, Your Lordship, since they are saying that they are family member and they have settled the matter, so there is a, Your Lordship, remote and bleak chance of conviction at this stage, after considering their mutual settlement, Your Lordship. So considering Your Lordship, the guidelines laid down in the Lakshmi Narayan case, Your Lordship.
Lakshmi Narayan is with you.
Yes, Your Lordship.
You have a copy.
Yes, Your Lordship.
What are the guidelines?
Yes, in para 15 is all the guidelines are there.
Read para 15.
Para 15, Your Lordship, 1-5.
Yes.
Yeah, may I read, Your Lordship?
Yes.
Considering the law on the point and the other decision of this court on the point referred to herein above, it observed and held as under the power conferred under section 482 of the code to quash the criminal proceeding for the non-compoundable offences under section 320 of the code can be exercised having overwhelmingly and predominantly the civil character, particularly those arising out of commercial transaction or arising out of matrimonial relationship or family disputes, and when the parties have resolved the entire dispute among themselves. Such power is not to be exercised in those prosecutions which involve heinous and serious offences of mental depravity or offence like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact on society. Similarly, such power is not to be exercised for the offences under the special statute like PC Act or the offence committed by public servant while working in the capacity are not to be quashed merely on the basis of compromise between the victim and the offender. The offences under section 307 IPC and Arms Act, etc. would fall in the category of heinous and serious offence and therefore are to be treated as crime against the society and not against the individual alone. And therefore, the criminal proceeding for the offences under section 307 IPC and of the Arms Act, etc., which have a serious impact on the society cannot be quashed in exercise of the power under section 482 of the code on the ground that the party has resolved their entire dispute among themselves. However, the High Court would not rest its decision merely there is a mention of section 307 IPC in the FIR or the charge is framed under this provision. It would be open to the High Court to examine as to whether incorporation of section 307 is there for the sake of it or prosecution has collected sufficient evidence which if proved would lead to framing charge under section 307 IPC. For this purpose, it would be open to the High Court to go by the nature of injury sustained, whether any injury is inflicted on the vital delicate part of the body, nature of weapon use, etc. However, such an exercise by the High Court would be permissible only after the evidence is collected, after investigation and the charge sheet is filed, charge is framed, and or during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion in para 29.6 and 29.7 of the decision of the Narendra Singh should be read harmoniously and to be read as a whole and in circumstances stated above, herein above. While exercising the power under section 482 of the code to quash the criminal proceeding in respect of the non-compoundable offense, which are private in nature and do not have a serious impact on society. On the ground that there is a settlement compromise between the victim and the offender, the High Court is required to consider the antecedent of the accused, the conduct of the accused, namely whether the accused was absconding and why he was absconding, how he has managed with the complainant to enter into a compromise, etc. Insofar as the present case is concerned, Your Lordship, this till 15.5 is the guideline, Your Lordship. Here it says, Your Lordship, even 307 falls under the heinous offense, Your
But
Lordship.
mere mentioning would not.
Yes, it will not suffice.
Mere
Meaning
mention-
thereby, court has to look into the material,
Yes.
whether it is for the namesake or not. And secondly, whether it is against the society or not. Now, since they are saying that they are family member on oath, Your Lordship, then on that basis, Your Lordship, it may be construed that it not against society or it is between the family, Your Lordship.
What injury was caused?
Lordship,
This is a joint application of it, Lordship.
Your Lordship, 323 is for the injury, Your Lordship. 323 itself is compoundable one, Your Lordship.
Heard Mr. What is your name? Kaku. D. Saikya. Heard Mr. D. Saikya, learned counsel for the petitioner. Also heard Mr. T. Ete, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed jointly by the petitioners, namely Shri Tasar Pradeep and Miss Shri Nangram Ragam alias Taran, praying for quashing the proceeding of GR case number 159/2006, which arose out of Itanagar PS case number 152/2006 under section 341/392/323 of the Indian Penal Code, and presently pending before the Court of Learned Chief Judicial Magistrate,
no, Lordship, Judicial Magistrate First Class.
pending before the Court of Learned Judicial Magistrate First Class, Capital Complex, UPR. The facts relevant for consideration of the instant criminal petition, in brief, are as follows. Number one, that on what is the date of FIR?
Lordship, 26/8/2006.
That on 26/8/2006, the petitioner number one, namely Tasar Pradeep, had lodged an FIR before the officer in charge of Itanagar Police Station, inter alia, alleging that on that day at about 14:30 hours, when he had parked his Bolero vehicle near in front of Akash Deep to call his brother, the petitioner number 2, Nangram Ragam, gave him one blow and snatched the keys of the vehicle from him. And thereafter, a group of people numbering about 8, a group of people having about 8 members pelted stones on the vehicle of the informant and ran away. Stop. Learned counsel for the petitioner has submitted that on receipt of the FIR, Itanagar PS case number 152/2006 was registered, and after completion of the investigation, charge sheet was laid only against the petitioner number 2 under section 341/392/323 of the Indian Penal Code in the year 2008. Stop. Learned counsel for the petitioner has submitted that though the charge sheet has been filed in the year 2008, the charges are yet to be framed against the present petitioner. He has also submitted that in the meanwhile, the petitioner number, who has married whom? Who married whom?
The petitioner number 1 has married the younger sister of the petitioner number.
In the meanwhile, after the incident, the petitioner number 1 had married the younger sister. After you're 42 years, when you married?
Now he's 42. At the time he was 20 years old.
Okay. Married the younger sister of petitioner number 2, and they are thus relatives, and they have amicably settled the dispute among them, and had also executed a deed of mutual settlement on 8th of July 2024. He also submits that in view of the mutual settlement arrived at between the parties, there is unlikelihood of a conviction resulting in the pending criminal case against petitioner number 2, and therefore, it would be futile to proceed with the criminal prosecution. And he therefore submits that for the interest of justice and to prevent the abuse of the process of court, the proceeding of GR case number 159/2006 should be quashed. On the other hand, Mr. T.A.T. Learned, additional public prosecutor, has referred to the observation made by the Apex Court of India in the case of the state of Madhya Pradesh versus Lakshmi Narayan and others, reported in 2019 5 SCC 688, and has submitted that though the offense under section 394 of the Indian Penal Code falls within the category of serious offense.
Yes, Lordship, it's 392.
392
92.
falls within the category of serious offense, however, mere mentioning of section may not be enough for not exercising the inherent power of this court in appropriate cases. In the instant case, only one blow was administered to the,
Brother-in-law.
this I will mention.
Yes, yes.
No, this line, only one blow, cut it. What is the last line? Inappropriate cases, stop. Stop. He submits that since the petitioners have approached this court by filing joint application, and since they are related to each other, there appears to be unlikelihood of the trial resulting in a conviction. Now, he has fairly submitted that. Stop. I have considered the submissions made by learned counsel for both the sides and have considered and have perused the materials on record. The Apex Court of India, in the case of State of Madhya Pradesh versus Lakshmi Narayan and others within bracket Supra, has observed as follows. Court para 15.1 to 15.5. Copy from the judgment and paste. Stop. In the instant case, it appears that the petitioner number 1, the allegation against petitioner number 1, petitioner number 2 is only of snatching away of keys of the vehicle, which learned counsel for the petitioner has submitted that have been returned back on the date of incident. It also appears that only one blow was administered to the petitioner number 1 by the petitioner number 2. And in the meanwhile, they have become relatives. Stop. It also appears that the petitioners have reached an amicable settlement and have also executed a mutual deed of settlement. And considering the nature of offense involved in this case, this court is of opinion that the offense involved in this case is mainly directed against the petitioner number 1, and no serious impact would be there on society if petitioner number 1 chooses not to pursue the criminal case against the petitioner number 2. Stop. It also appears that in view of the amicable settlement arrived at between the parties, there is unlikelihood of the criminal proceeding pending against the petitioner number 1 resulting in a conviction. And this court is therefore of the considered opinion that it would be futile to continue prosecution of the petitioner number 2 in GR case number 159/2006. Stop. In view of above, for the ends of justice and to prevent the abuse of the process of court, this court is of considered opinion that the GR case number 159/2006, which arose out of Itanagar PS case number 152/2006 and presently pending before the Court of Learned Judicial Magistrate First Class Capital Complex UPA is required to be quashed. This court accordingly quashes the aforesaid proceeding, and this criminal petition is accordingly allowed and disposed.
Obliged, Your Lordship.
Return back this.
Item number 7.
Your Lordship, since the provides for obligatory hearing of the
Victim,
application if under section 65, Your Lordship. This is a case under 65.
what is 65?
65 is punishment for rape, Your Lordship. So they were directed to take steps during the course of the day. However, they are taking the steps only on 19th,
So, service is not complete.
not
or-
complete, Your Lordship.
My lord, service was taken, but due to some miscommunication gap, it was not served on the course of the day.
No, it was duly served. There is a,
It was served, my lord. We have taken steps.
there is a office note.
Yes, office note states that they have taken steps on 19th.
No, but office note dated 22/8/2024 says that the report, service report in respect of respondent number 2 has been received back from the CGM UPA after due service.
It, if I might just look into, Your Lordship.
What is the offense?
My lord, often is under
What is
section
the age of the victim?
age of the victim. might
14
be,
years.
As per FIR 14 years. So here, my lord, this accused applicant, they have never been commit under section 4 of POCSO Act, which made allegation in the FIR. my lord. Only on the day of incident, this both accused was here in the item number 7 and 8 arising out of same FIR. my lord. So they were together with the one of the prime accused, who is known as one Keen Bai. So only on the allegation against this accused person is that, my lord, there was a criminal conspiracy to commit rape of the victims. That was the only allegations.
Your Lordship, in that case, since the POCSO,
Legal aid counsel. has
yes,
to be
Your Lordship, appoint for a
We'll
legal aid.
appoint a legal aid counsel
My
to
lord, so-
defend the cause of.
Yes,
the
Yes, my
victim.
lord, if
Who will appoint? Registry will appoint.
Your Lordship can also appoint if Your Lordship have the list of
Where,
the,
is there any legal aid counsel present in the court now? Anybody? You defend? Heard, Mr. Whether case diary has arrived.
yes, we have received the case diary, Your Lordship.
So how much time will you require? We'll fix it on Monday or Tuesday.
my lord, here in the case, one of the accused, they are having serious health issues.
We'll
Unfortunately-
issue direction for medical treatment.
Yes.
My lord, the doctor,
But let the legal aid counsel prepare himself.
Yes, Your Lordship.
all right,
Okay.
on Monday, 26.
26 is holiday. 28. Heard Mr. N.
Lordship.
Rama.
Lordship, copy may be furnished to me. Lordship.
Yes, I heard Mr. N. Rama, learned counsel for the petitioner, also heard Ms. T. Ginny, learned additional public prosecutor. On perusal of the office note dated 22/8/2024, it appears that service report in respect of respondent number 2 has been received back from the Court of London Chief Judicial Magistrate UPR after due service of notice. However, no one has appeared for the victim. In view of above, this court is inclined to appoint one legal aid counsel to defend the cause of the victim in this proceeding. Accordingly, Mr.
G. Genie.
G.
Genie.
G. Genie, learned legal aid counsel is hereby appointed to defend the cause of the victim in this case. The learned counsel for the petitioner is directed to furnish a copy of bail application along with annexures to the legal aid counsel, to newly appointed legal aid counsel during the course of the day. Learned additional public prosecutor has informed that the case diary has already arrived. Same may be retained.
Updated case because the investigation is still going on. Updated case.
You will receive it by Tuesday.
Is from the women police station.
Okay. Same may be returned
My lord,
back.
again, if case diary will return, then if on 28th, they will fail to furnish on 28th, again, it will difficult, my lord.
Here only, women police station.
She
So till 28th, the case diary may be returned, my lord.
The investigation is going on, your lordship.
investigation is
Yes.
going on.
Now accused, they are in judicial custody, my lord.
Because
In fact,
if-
I of
Now
the
we will
case.
consider.
Yes. In fact, in item number 8, which was taken as the same issue, your lordship, there has been a clear direction from this court that if there is any medical issues, the jail superintendent may look into the same, your lordship. In item number
in
8,
this-
We are coming to item.
yes.
My lord.
The case diary may be returned back and an updated case diary may be called
Yes.
on the next date fixed, that is 28/8/2024. Next item. Next item,
Item number 8 is also same, your lordship.
same order,
Yes, my lord,
Arising out of same FIR, your lordship.
allegation is same. But-
same order, same legal aid counsel. No, not same order. Heard Mr. N. Rama, learned counsel for the petitioner, also heard Ms. T. Genie, learned additional public prosecutor. On perusal of the office note dated 21/8/2024. It appears that though the notices were issued to the respondent number 2 on 19/8/2024, however, no report as regards service of notice has been received back by the registry of this court. Learned counsel for the petitioner has submitted that this case arose out of the same FIR and the same incident as in the case of bail application number 85/2024, where the notices were already served on the respondent number 2. And in that case, a legal aid counsel has already been appointed for the respondent number 2. Here, in view of that notice, we are not waiting.
Yes, your
We
lordship.
are appointing him as legal aid counsel. In view of above, this court is of considered opinion that instead of waiting for the service report in respect of respondent number 2, this court may appoint a legal aid counsel to defend the cause of respondent number 2 victim in this case. Accordingly, Mr. J. G. Ginny is hereby appointed as legal aid counsel in this case to defend the cause of respondent number 2. The petitioner is directed to furnish a copy of bail application along with the annexures to newly appointed legal aid counsel for the respondent number 2. Learned additional public prosecutor has submitted that the case diary is available. However, she prays that same may be sent back for updation. The prayer is allowed. Let the case diary be sent back to be called again after updation before the next date fix. It is submitted by the learned counsel for the petitioner that the petitioner is suffering from what?
My lord, he was conducted brain surgery in the month of January 2024 at Guwahati, GNRC Guwahati. So now attending doctor has advised him to recheck up, review after 4 months. So it's almost four months is running, my lord. He was got serious accident, my lord.
He submitted
So
that
in District Jail, Julie, there is no
on-
such
on the-
neurosurgeon expert is
on
there.
the next date we will consider.
My lord.
Submitted that the petitioner has undergone a brain surgery in the month of January 2024, and he requires a review of the same
My lord, which is,
after
lordship,
four-
which is clearly mentioned in page number 33 in my
after
bail
4
applications.
months of the said surgery, and the 4th month is now running. Stopped. The superintendent, which jail he's
Page number 33 is medical
no,
advice from
which-
the attending doctor.
Which jail he's detained now? Which jail?
My lord, District Jail, Julie.
District jail?
District Jail, Julie.
Julie.
District Jail, Julie.
Julie is
There is no such medical expert, my lord.
directed to provide all necessary medical treatment and also directed to furnish a health status report of the petitioner to this court before next date fixed, that is on 28/8/2024. List this case again on 28/8/2024 along with bail application number 85/2020.
Lordship, your lordship, just a small clarification regard to that, your lordship. In item number 7, named as Tacha Rema. This is the applicant where the medical they have annexed the medical documents, your lordship.
But it is not mentioned.
Yes, your lordship. Your lordship, in item number 7, the
Who is-
petition have
Who is Hail?
Tacha Tajik, who is the elder brother of the accused,
Whether
Tacha Tade.
Whether Tacha Tajik is ailing or Tacha
No, my lord,
Rema.
Tacha Tajik is elder brother of the accused
No,
person,
no, that
Tacha
is not the
Tade.
question.
Tacha Tade.
Who has undergone brain surgery?
Tacha Tade, my lord.
Tacha Tajik.
Yes, Tade.
which is represented in item number 7, your lordship.
No, in 8.
Tacha Tade.
Tacha Tajik is in 8.
Tacha Tade, your lordship, because Tacha Tade, if your lordship will see it, Tacha Tajik.
Tacha Tade is item
Yes, yes,
number
your
8, my
lordship,
lord.
I deeply apologize. My file has been swapped.
Okay, list according.
deep-
Much.
As per the last order, I have taken Dusty service to the respondent in 3 and 4. 2 and 3.
Have you filed any affidavit?
No, my lord, not
You
yet.
have to file an affidavit of showing that you have served through the mode. File an affidavit.
Okay, ma'am.
Heard, Mr. What is your name?
M. Lago.
M.
M. Lago. L-E-Z-O.
M. Leno.
Yes.
Learned Counsel. learned counsel for the petitioner who submits that the petitioner has already taken steps for serving the notice on respondent number 2 and 3 through Dusty mode and have effected the service also. However, he prays for some time for filing an affidavit of compliance in that regard. The prayer is allowed. Also, Mr. G. Tado, learned additional public prosecutor. Let this matter be listed after
2 weeks, madam. 2 weeks.
2 weeks. After 2 weeks. In the meanwhile, the petitioner may file the affidavit of compliance before the registry.
Item number 10.
Your Lordship, at last occasion, this court has directed to take fresh step and to respondent number 5, 7, and 8, and it has been taken.
You have not taken steps.
We have taken, already taken.
You have taken,
Yes,
but notices. But service report is awaited. When have you taken steps?
at 22/6.
What should we do? We
Okay.
should await service or you will take fresh.
Actually, Your Lordship, for respondent number 5, 7, and 8, it has taken many time. It's been almost 3 or 4 times. It's already
Now,
taken.
what do you suggest? What,
If this court can, then it may be dropped. Or because Dusty is not possible, because they are laborers and they work, goes one place to another according to their work.
who are they? What is the issue here?
They were the main victim in this,
They are victim.
they are the victim. In fact, as respondent number 4 is the person who has engaged them, Your Lordship. 5, 6, 7, 8 were the victims who had been
What-
assaulted.
They have been assaulted.
Yes.
Then notice is necessary. You have to take steps.
Then,
Take fresh steps. Where do they reside? Siming Sapore, Dhemaji. Take steps through registered post and then submit the postal tracking report from where we can find out whether the services are.
Your Lordship, actually, we have served from through every procedure we can. This by order dated 8/6/2024, it was directed to take step through official in charge of the concerned jurisdiction police station rotated through the office of public prosecutor. And it is still awaited.
You can take information, Ms. Ginny.
Yes, Your
You
Lordship,
can
in
take information from the concerned.
police station. In fact, Your Lordship, if that is the procedure, Your Lordship, the registry ought to give us the notice format, Your Lordship. Then we give it to the jurisdictional police station who on receipt, or if not, the addresses are not found, give back the information of the notice. Your Lordship. The procedure, if I may, Your Lordship, if it is to go,
What is the police station? Police
Because
station is not.
the police station of 5, 6, 7,
You can speak to the OC over telephone.
yes, 5, 6, 7 are from Dhemaji, Your Lordship, if that is, and 8 is from Manipur, Your Lordship.
Oh.
So we'll have to also find it out. We have to be served with they ought to have given copies in the registry. The registry will be giving us the notice copy, Your Lordship.
And then how will you send
we'll be sending it through the SP's office, Your Lordship.
Heard, Miss, what is your name?
A. Rai.
Heard, Miss A. Rai, Learned Counsel for the petitioner. Also heard Miss T. Ginny, Learned Additional Public Prosecutor. On perusal of the office note dated 21/8/2024, it appears that the notices, no service report in respect of notices issued to respondent number 5, 7, and 8 has been received back by the registry. Only these three are remaining. Others?
Yes, others are already served.
4, 5, and 6, and 4, 5, 6, 7, and 8, Your Lordship, 4 of them.
Six.
No, 6 is already
Six
served.
has been served. 5, 7, and 8. Learned Counsel for the petitioner has submitted that petitioner has taken steps on several occasions for service of notice to the aforesaid respondents. However, all attempts have been made in vain, and the notices are yet to be served as neither AD cards nor unserved notices returns back from in case of the aforesaid respondent, as all the three respondents resides outside the state of Arunachal Pradesh. Stop. In view of above, the petitioner is directed to take fresh steps for service of notice on the aforesaid respondent through the officer in charge of jurisdictional police station. Stop. The petitioner shall submit the written up notices to the registry of this court, which in turn shall furnish the same to the office of the public prosecutor, Arunachal Pradesh, who shall ensure the due service of notice of the same through the officer in charge of jurisdictional police stations, and thereafter, after service of the notices on the aforesaid respondent, the officer in charge of jurisdictional police station is directed to submit the service report back to this court through the office of the public prosecutor.
Your Lordship may.
Your Lordship, and in meantime, this interim order may be continued.
The petitioner shall take step for issuance of notices as aforesaid within 7 days from the date of this order, returnable in 3rd week of September 1. Date. 3rd week, any date. No, 3rd week of September. 3rd week of September. 18. Let this case be listed again on 18th of September. The interim order shall continue till next day. What is to be done?
Your Lordship may record their absence, Your Lordship, and fix this matter after some time, after some days.
None appears for the petitioner on call. Heard Miss T. Ginny, Learned Counsel for Additional Public Prosecutor. Learned Additional Public Prosecutor. Stop. It appears from record that on last occasion also the None, the counsel for petitioner was absent, found absent on call. Let this matter be listed again after a week
Yes.
or date to be fixed by registrar.
The-
This matter seems to be registered wrongly in orders column. As per last order, it was to be listed in admission column for admission hearing.
What is the case?
This is petition for quashing of the FIR.
FIR?
Yes, which is registered under section 8 of POCSO
No,
Act.
but the POXO matter is there. So even for admissibility, the counsel has to be appointed to defend.
It is a joint petition, Your Honor.
Joint
Yes,
petition.
joint petition.
The victim has also filed an application.
Yes, yes. Ground for quashing is that they have arrived into a settlement. Only ground is that. That is not the case, Your Lordship. It is not like settlement of the other cases. My case is completely entirely different from the other POCSO cases because the fact in this case, Your Lordship, is that the FIR was lodged in confusion by mistake of fact. That is the ground. And even if we go by the deed of settlement also, the same thing is mentioned, that FIR has been lodged out of confusion and in fear. So Your Lordship, kindly allow me to give my
No,
submission.
section 8 offense is there.
One is section 8 of POCSO. So
Section 8 is sexual assault.
Sexual assault. Prosecutor's hearing was already examined by the court, the court, and it is in the LCR. We have received that.
Scan copy have.
Yes. Folder C. So
Then let what she has deposed before the trial court.
she has clearly stated that she has not been touched inappropriately. No. It is. She clearly stated. Your Lordship, if we look at her deposit, Your Lordship, may I give my detailed submission if Your Lordship permits? In serial 4. If we look at this one, point 4, Your Lordship, point 4 of our deposition, point 4, 5, 9.
No,
And
just
for-
a minute.
Folder C.
File C. No, the victim has been examined.
Yes. Victim and complainant improvement.
No, she has implicated you.
Yes, in Your serial Lordship? 4.
She has implicated you.
No, Your Lordship, let's go to the point 4, Your Lordship.
Point
4
of
Oh.
the,
of the deposition of PW1.
ah,
May I read for Your Lordship?
yes.
When I was leaving his kitchen after preparing his meal,
He suddenly hugged me from backside once by crossing his arms over my chest. The victim and the complainant, they are close relative. The accused being the cousin brother-in-law and their neighbors. So frequently they used to come to each other's house and meet each other on daily basis.
Cousin brother,
Cousin, no,
from
not
where
cousin
are
brother.
you saying cousin brother?
It is even in the even in deposition also.
Where?
This of the PW1 also. The point one.
Point number?
One. Not cousin brother, he is cousin brother-in-law. He is Docha Tagum, husband of my elder cousin sister. And even in the deposition of PW2 also,
Okay.
he says he is my cousin brother-in-law. So now they are close relative. Since they are close relative to each other, they used to meet each other on daily basis. Now what happened on that day, on 10/3/2023, the victim girl, Miss X, she went into the house of her aunt. And on that day, the accused also came and she asked the victim girl to come to his house and to help him in.
Washing of the proceedings of POCSO case number 3/2024 within bracket Z, arising out of Raga PS case number 6/2024. Under section, under what provision charges were framed?
Section 8 of POCSO.
Only 8.
And 354A, I guess.
Under section 8 of the POCSO Act, 2012, and section 354A of the Indian Penal Code, presently pending before the Court of London, Special Court, POCSO, Sessions Court, 0. The facts relevant for consideration of the instant criminal petition, in brief, are as follows. Number 1, that on 11th March 2024, the father of the victim, within bracket, the petitioner number 1 in the instant criminal petition, had lodged an FIR before the officer in charge of
Raga PS.
petitioner number 2. What? Read the last line. Instead of petitioner number 1, make it petitioner number 2. Yes, read the last line. Officer in charge of Raga police station, inter alia, alleging that the petitioner number 1, namely Docha Tagum, had molested the daughter of the informant on 10th of March 2024 at his residence. It was also stated in the FIR that the daughter of the informant, within bracket, petitioner number 3 in the instant criminal petition, was under the age of 15 years at the time of the incident. Stop. Next para. On receipt of the said FIR, Raga PS case number 6/2024 was registered under section 354 of the Indian Penal Code, read with section 8/10 of the POCSO Act, 2012, and investigation was initiated. Next para. After completion of the investigation, where is the LCR? After completion of the next para. After completion of the investigation, charge sheet was laid against the petitioner number 1, namely Docha Tagom, on 13/5/2024 under section 354 of the Indian Penal Code, read with section 8/12 of the POCSO Act, 2012. Stop. The petitioner number 2 was arrested after lodging of the aforesaid FIR, and when you got bail,
No, I'm still in custody.
arrested after lodging of the FIR, and he is facing the trial, remaining in custody. Stop. Next para. On 10/6/2024, the Court of London, Special Judge POCSO, which place, which district?
Lower Subansiri.
Huh?
Lower Subansiri.
Lower
Lower.
Subansiri.
Yes.
Lower Subansiri. This last line, read last line. Okay. London Special Judge POCSO, Lower Subansiri, framed charges under section 8 of the POCSO Act, read with section 354A of the Indian Penal Code, against the petitioner number 2, petitioner number 1, Docha Tagom. Stop. When the said charges were read over and explained to the petitioner number 1, he pleaded not guilty and claimed to be tried. Pleaded not guilty and claimed to be tried. Stop. Next para. Docha Tagom. Mr. Kago Taja, learned counsel for the petitioners, has submitted that after framing of charges against the petitioner number 1, the prosecution side have already examined the main witnesses, namely the victim as well as complainant, as PW1 and PW2 respectively. Stop. He also submits that in her testimony before the trial court as PW1, the victim has deposed that the petitioner number 1 is the husband of her elder cousin sister, comma, her elder cousin sister, stop. Learned counsel for the petitioner thus submits that the petitioner number 2 is therefore related to the petitioner. Petitioner number 1 is therefore related to petitioner number 2 and the victim girl. He also submits, learned counsel for the petitioner also submits that though in her deposition before the trial court as PW1, the victim girl has stated that the petitioner number 1 that stated that while petitioner number 1 has stated that in the month of March 2024, no, gadbad ho gaya. You read the last para. In the month of March 2024, on the request of her father's sibling, Srimati Gotak Mami, Godak Mami, Godakmami, she went to her residence, which was situated in Medical Colony, Yada, to take care of her children. Stop. And the petitioner number 1 at that time came to residence of Srimati Godak Mami and requested the victim girl to prepare meal for him as he was alone in his house. Stop. On his request, the victim girl came to the house of the petitioner number 1, which is located near Medical Colony Yada. Stop. She also deposed that learned counsel for the petitioner has submitted that the victim girl also deposed that while she was leaving the kitchen after preparing meal, the petitioner number 1 suddenly hugged her from backside by crossing his arms over her chest and touched her breast. Stop. She also deposed that the petitioner number 1 seemed to be in inebriated condition, and therefore she did not like his behavior and immediately left his house. Learned counsel for the petitioner has submitted that the victim girl has also deposed in her testimony, deposed as PW1 before the trial court that the petitioner number 1 followed the victim girl to the house of her aunt Srimati Godak Mami and begged pardon by saying that he did not had any bad intention and was hugging her only to say thanks to her. Learned counsel for the petitioner has also pointed out that the victim girl has categorically stated in her testimony that the petitioner number 1 did not hug or touched her inappropriately on any other day except on the date of the incident. Stop. Learned counsel for the petitioner has also submitted that during cross-examination, the victim girl has categorically stated that the petitioner number 1 did not hug her with bad intention and touched her breast by mistake only. Stop. Learned counsel for the petitioner has thus submitted that from the testimony of victim girl before the trial court, it is apparent that no offense under Section 8 of the POCSO Act, 2012 or Section 354A of the Indian Penal Code has been made out against the petitioner in this case. He further submits that in addition to that, the complainant, who is the father of the victim girl, and the petitioner number 1 have arrived at an amicable settlement between them. And to that effect, a deed of agreement has also been executed between them. On 18th day of June 2024. Wherein it was agreed between the parties that the petitioner number 2 between the parties that the matter has been settled amicably between them and the criminal case pending against petitioner number 1 would not be pursued by the complainant or the victim girl.
The first point is the availability.
First,
The first point of the agreement. The first point of the agreement, where it is reflected that,
it was also. No, I'm not getting you. First, what do you want to state?
the contents of the agreement, where it reflects that the FIR was lodged out of Mr. Aras.
Okay. It was also it was also mentioned in the settlement reached between the parties that the FIR was lodged against the petitioner number 1 by the petitioner number 2 due to mistake and confusion as later on the petitioner number 2, who is the complainant, was informed by victim that she was not touched inappropriately by the petitioner number 1 as alleged by him, as alleged by petitioner number 2 in the FIR. Stop. Learned counsel for the petitioner has also submitted that though the petitioner number, though the complainant and the victim have deposed before the trial court by stating the true fact wherein the petitioner number 1 have not been implicated, and there is every likelihood of the trial ending in acquittal of the petitioner number 1. However, there are 5 more witnesses who are yet to be examined, which would certainly take some time. And
It will be 6 witnesses as per the charge sheet.
total 6.
Total is 8.
6 more witnesses.
Yes, excluding the IO and the doctors.
And in view of the settlement arrived at between the parties, as well as the deposition of the PW2 and PW1 before the trial court, there is unlikelihood of the case ending up in conviction, and therefore it would be futile to proceed with the trial of petitioner number 2, petitioner number 1 in this case. Stop. Learned counsel for the petitioner also submits that though Section 8 of the POCSO Act has been mentioned, though charges were framed against the petitioner number 1 under Section 8 and Section 8 of the POCSO Act, as well as Section 354A of the Indian Penal Code. However, this court, in exercise of its power under Section 482 of the Code of Criminal Procedure is not precluded to look into the evidence which is on record to see as to whether the evidence available on record would lead to proving of charges framed against the petitioner and would ultimately lead to conviction. He further submits that if High Court finds that the evidence may not lead into conviction, it would be futile to proceed with the criminal proceeding pending against the petitioner number 1. Stop. He also submits that as the petitioner number 1 and the complainant and as well as victim are related to each other and they have reached an amicable settlement between them, the High Court may exercise its power of quashing the proceeding in the aforementioned case to for the ends of justice and to prevent the abuse of the process of court. Stop. He also submits that learned counsel for the petitioner also submits that the case of the petitioners squarely falls within the condition numbers C enumerated by the apex court in the case of State of Haryana versus Bhajanlal and others reported in dash
21 November 1990.
reported in
21 November
no. There is a
1990.
citation. You keep that citation blank. I'll fill it up. Reported in so and so, wherein it has observed that where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of same do not disclose the commission of offense and make out a case against the accused, the High Court should exercise its power under Section 482 of the Code of Criminal Procedure to quash such case. Stop. In support of the submissions made by learned counsel for the petitioner, he has relied upon following judgments. That is, number 1, State of Madhya Pradesh versus Lakshmi Narayan and others, reported in what is the SEC citation?
This, 5th March.
2019,
Yes.
5 SCC 688. And number 2 is State of Haryana versus Bhajanlal and others reported in dash. I will give you the citation later on. Stop. On the other hand, Mr. G. Tado, learned additional public prosecutor, has vehemently opposed the prayer for quashing of the proceedings of special POXO case number 3/24 within bracket Z against the pending against the petitioner number 1 before the court of learned Special Judge POXO, Session Judge, 0, Lower Subansiri District. Stop. Learned additional public prosecutor submits that as the offense charged against the petitioner number 2 is under special law, that is the POXO Act, 2012. And as the apex court has observed in the case of Madhya Pradesh, state of Madhya Pradesh versus Lakshmi Narayan and others within bracket Supra, that the powers of quashing should not be exercised in case of offenses which are under special statutes. Stop. Learned additional public prosecutor has also submitted that the offenses under POXO Acts are serious offenses involving mental depravity and having serious impact on the society. And as in the instant case, the petitioner has been charged for the offense of committing sexual assault on a minor girl, punishable under Section 8 of POXO Act. The High Court should not show any benevolence in favor of the petitioner.
Yes. One submission in this point.
And should not quash the proceeding against the petition number 1. Yes, what submission?
As regard the for special statutes which is mentioned in the Lakshmi Narayan, it mentions
Only prevention of
yes,
corruption.
but the public servant. That apart, we have to see the punishment also.
Like prevention of corruption.
in Lakshmi Narayan.
No,
What like?
I have already made up my mind. Now I am dictating only.
Yes, but you know,
I'm just-
in Lakshmi Narayan, 307 has been interpreted, and the punishment is more than 7 years. But although in the case like this POXO, it is only maximum is only 5 years. You know, see. That may kindly be.
Okay, what was the last line? What is your name? What was the last line? Yes, learned additional public prosecutor has also submitted that the victim girl has in her statement made before trial court as PW1 has categorically implicated the petitioner number 1 by stating that the petitioner number 1 had hugged her from backside by crossing his arms over her chest and touched her breast in an inebriated condition. And the said behavior was not liked by her when the petitioner number 2 did so. Petitioner number 1 did so. He also submits that as the victim girl is a minor, the question of her consent in such case is of no relevance and immaterial. Stop. Learned additional public prosecutor has also submitted that only 2 witnesses have been examined in the trial pending against the petitioner number 1, and 6 more witnesses are yet to be examined. And out of those witnesses, there are some witnesses to whom the victim reported the incident immediately after occurrence of the incident. And therefore, their testimony would be relevant in deciding the charges framed against the petitioner number 1. Stop. Learned additional public prosecutor also submits that under above circumstances, the settlement arrived at between the parties is of no relevance, and same should not be taken into consideration by this court while considering the instant criminal petition. And he prays for dismissing the criminal petition filed by the
It's a
jointly filed by the petitioners. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of the case record of POXO case number 3/2024. Stop. How many cases are there remaining? We will continue after lunch. You have to come again. We will dictate. We will continue after lunch.
Obliger.
In the instant case, the petitioners have jointly approached and have filed the petitioners, who are the accused, the complainant and the victim respectively, have filed the joint petition under section 482 of the Code of Criminal Procedure for quashing of the criminal proceeding pending against petitioner number 1. It has been settled in the case of, it has been settled by the apex court in the case of State of Madhya Pradesh versus Lakshmi Narayan and others within brackets Supra, that when the parties have reached the settlement and on that basis petition for quashing of criminal proceeding is filed, the guiding factor in such cases would be to secure, number one, ends of justice, and number two, prevent the abuse of the process of court. Stop. In the instant case, the parties have approached this court for quashing of the criminal proceeding pending against the petitioner number one at an early stage of the trial when only 2 of the 8 prosecution witnesses listed in the charge sheet have been examined. The power conferred under section 482 of the Code of Criminal Procedure, 1973, may be exercised to quash a criminal proceeding in respect of non-compoundable offenses under section 320 of the Code, if such a dispute arose within the members of the family. Such a dispute is a family dispute and the parties have resolved the entire dispute amongst themselves. Stop. In the instant case, the dispute, though may not be regarded as a family dispute, however, fact remains that the petitioners are related to each other and they have settled the dispute between them. Moreover, the allegation against the petitioner number 2 also. Petitioner number 2, yes, is, now what is the last line? Moreover, the charges framed against petitioner number 2 is, petitioner number 1 is under section 8 of the POCSO Act for allegedly committing the offense of sexual assault. Stop. If we look at the definition of sexual assault as provided under section 7 of the POCSO Act, it provides that whosoever with sexual intent touches ... or breast of a child is then ... No, you quote section, quote entire section 7, quote entire section 7. If on cursory perusal of the aforesaid provision, after quoting section 7, on cursory perusal of the aforesaid provision, it would appear that mere touching of the breast of a child in itself would not constitute an offense unless it has been done with sexual intent by the accused. Stop. However, in the instant case, if we peruse the testimony of victim recorded during the trial as PW1, she has categorically stated in her cross-examination that it is true in her cross-examination as follows within inverted commas. It is true that he did not hug me with bad intention and touched my breast mistakenly, inverted comma, close. The complainant, if we look at, if we consider the testimony of PW2, that is the complainant of the case named as well as petitioner number 2 in the instant case, he also deposed before the trial court that the victim, that he also deposed before the trial court as follows within inverted comma. The victim told me that the accused came to the residence of Shrimati Godak Mami and expressed that he did not have any bad intention but hugged her casually and sought pardon. She had pardoned him after informing me over telephone. If the above evidence is considered along with the fact that the matter between the parties have been settled by virtue of a deed of an agreement dated 18 June 2024, wherein it was affirmed that the FIR was lodged against petitioner number 1 due to mistake of fact from a misunderstanding and communication gap. And it was learned.
This has happened, Lordship, when this, the petition number 1 and 2, where is police going student, Lordship. And now they are all, now the petitioner number 1 is 43 years and petitioner number is almost 50 years, Lordship.
In 99.
Yes, Lordship.
Now what is happening in the trial? Why it is not proceeding?
Lordship, the trial has just, they were shocked, Lordship.
Whether it was stayed?
It stayed, Lordship.
When? On your petition?
On the last date, Lordship, on 7/7/7 of.
Then why the progress is so slow? The FIR was lodged in the year 1999.
Yes, Lordship.
When the charge sheet was filed?
charge sheet was filed in the year 99 itself, Lordship. At that point of time, Lordship, the cases were handled by the executive magistrate. Maybe during that time, the file got closed somewhere or like, but after the matter coming before the Lanet JMFC Capital Complex, and accordingly, after taking cognizance, they have summoned to the alleged accused person, that is petitioner number
When
2.
the summons were issued?
Someone were issued by Lordship in 23/4 of 2024. That which I have,
And at what stage the case is
it's
pending?
for appearance, Lordship.
Appearance stage?
Yes, Lordship.
Inquiry stage.
It's in initial state in the year 99, Lordship. That's why we are,
You have which offenses?
354.
354.
350. Where is the FIR?
FIR, it's Lordship in page 15. The type copy, Lordship.
No, attempt to rape is there.
Lordship, this was,
This was the,
yeah. This was the initial Lordship, since I have made a special category aberment in my petition also, they had a liking for each other, Lordship, and they were student at that point of time.
then if there was a liking, why you strangulate her?
At night, Lordship, the petitioner number 2 had gone to her room on coming, being awakened by the family members. Yes, that my Lordship, since now,
At that time, what was your age?
that time, Lordship, I was like,
The accused was at of
Lordship, just, the accused was maybe 24, Lordship, something.
now what is your age?
Now it's 50 years, Lordship.
Yes, Mr. Hete. Now, what is your ground? The settlement has been arrived.
Lordship, yes, settlement has been arrived between both of them. And Lordship, they are now living their own life. The petitioner number 1 and 2, they have, she's also married, and the petitioner number 2 is also married. They have their own family to look after. And the petitioner number 1 is also a teacher, and petitioner number 2 is a scientist by profession.
Lady is a scientist.
Yes, Lordship.
Where is the settlement?
The settlement agreement is.
But
page
there was
52.
an assault. Where is it? At page?
Page settlement is page 57, Lordship. Deed of mutual settlement agreement. In HR 5, page 57, Lord.
In which category now you fall of the Supreme Court has laid down guidelines in Lakshmi Narayan, in
Yes, Lordship.
Bhajan Lal. Now, you are not relatives, first of all.
We are not relative, Lord.
You are claiming to be friend.
Friend, Lordship, their friend. At that point of time also their friend, now also Lordship, their friend. And moreover, Lordship, had it been, this is what that had happened in the year 99, Lordship. At that point of time, Lordship, even I was a student.
No, but there, because there is no, this limitation is
Yes,
there
Lord.
in respect of certain offenses.
Mm.
468 is not,
468,
is not applicable in
Yes.
some offenses.
Lordship, 468, in my understanding, it's not applicable in any, like, 468.
No, there is a limitation provision,
Oh, yes, on CRPC, your lordship.
CRPC.
The 468, yes, it's speak about your lordship from the day of incident till filing of the complaint or registration of the FIR, not the filing of the charge sheet, your lordship.
Oh,
That has been, actually, there was a, your lordship, great confusion, even Sarah Matthew case, Japani Sahu
now
case.
what has been held?
Sorry, your lordship.
What is the law now?
Now, your lordship, the law is, your lordship,
From the
new
date of-
code is very clear now. Explanation is given in the new code BNSS. However,
It has been made clear.
it made clear, explanation has been given. For the purpose of computation, it will be computed from the date of commission of the offense,
Till the-
or when it come to the knowledge of the party, and then till the filing of the complaint before the magistrate or before the
FIR.
police.
FIR.
FIR, yes.
Lodging of FIR.
Yes, yes, your lordship.
Okay,
That is clarified.
okay.
Here, FIR is filed well within time.
So in this case, the fact that the incident occurred 25 years ago,
Yes.
does it have any relevance in consideration of the incident?
Your lordship, the consideration here would be, your lordship, the Lakshmi Narayan case, it's a general guiding factor. There are other cases are also there, Kapil Gupta case, where peculiar circumstances has been considered.
This is a peculiar circumstance.
Yes, your lordship. Because they both are now married and they both are stay happily with their respective family member. And at that, according to their, your lordship, their apartment made in the petition, at that point of time,
And moreover, the witnesses which might have been cited in the charge sheet
yes, your lordship.
are of 25 years ago.
Yes, your lordship.
So what they remember,
There is an inordinate delay, in fact, your lordship.
that is also.
This is also one of the factors, your lordship.
Which judgment? Now, complete your submissions.
Lordship, I would like to give the Lakshmi Narayan is there, as well as Lordship, I would say Kapil Gupta was.
Lakshmi Narayan, which portion helps you?
Lordship, that would be,
Read out the portion which helps you.
Lordship, I have not. got
Barely citing Lakshmi
the-
Narayan.
Lordship, I've got this Kapil Gupta verses, because here, Lordship,
Which portion helps you?
Kapil Gupta, Lordship, I'll say. That would be paragraph 12.
Read out. Whatever helps you, please read out.
While deciding whether to exercise its power under section 482 of the court or not, timing of settlement play a crucial role. The case where the settlements arrive at immediately after the alleged commission of offense and the matter is still under investigation, the High Court may be liberal in accepting the settlement to pause the criminal proceeding / investigation. It is because of the reason that the investigation is still on and even the charge sheet has not been filed. Likewise, those cases where the charge is framed, but the evidence is yet to start or the evidence is still at infancy stage. The High Court can show benevolence in exercising its power favorably, but after prima facie assessment of circumstances / material mentioned above, on the other hand, where the proceeding event is almost complete or after conclusion of evidence, the matter is a stage of argument. Normally, the High Court should refrain from exercising its power under 482 of the court. As such case, the trial court would be in position to decide the case finally.
No, that may not help you. But in this case, one peculiarity is there,
Yes.
that the time gap is so much,
So much, yes, Lord.
25 years.
Yes, your lordship. And the second aspect is, your lordship, erstwhile relationship, whether there any relation between them, so far as their,
Whether you had any relationship,
both the party.
you had any love affairs,
Lordship,
with-
that I have made, they had a liking for each other. They had
where
made-
have you stated? Where have you
Oh,
stated?
I'll just,
Or it is only council stating?
I'll just. Lord.
Whether the parties have stated that they had liking to each other? Now they will not state both are married.
Yes, your lordship. They both are married, respective families are there.
No, have they stated that at that time there was a one aspect may be there, the petitioner number 1 is the main witness, prime witness.
Yes,
When she has compounded,
yes.
it is unlikely that she would be deposing anything against.
Again, remote and bleak chance comes in.
Then again, the possibility of conviction is
It's like
like
remote bleak and.
Lordship, in
And-
my paragraph 6, I make.
Para 6 of
Yes,
your
Lordship, page
petition.
5, yes, Lordship. Page 5, Lordship.
Yes,
Paragraph 6, Lordship, married. In the year 99, the petitioner who were student at that point of time had feeling for each other. As such, one fine night, the petitioner number 2, after taking alcohol, had entered into house of the petitioner number 1
and sneak into her room. So they have
Who swore the affidavit? Lady or both have signed the
yes,
affidavit?
both have signed lordship.
Both have swear.
Yes. What is your submission?
Well, my submission, your
Yeah.
lordship. So see, there is an, your lordship, so as long as they settle the matter, your lordship. Now the only ocular witness is the victim itself, your lordship, the
Okay. The sole ocular witness is the
one
petitioner number one.
One only, yes, your lordship. At the time when offense was alleged to be committed by the respondent number or petitioner number 2. And your lordship, there is an inordinate delay.
The reasons for delay has not been mentioned, no?
Yes, your lordship. It's way back in 1999, you'll perhaps at that point of time they were not separate. The
Lord, I have made my environment of the lordship after the incident, both the family, like they had a meeting together and
Where have you mentioned?
our lordship in my environment I have given and like
Which para?
I will come down. That is in the paragraph 6 itself, lordship. Mary Jonah, like. that
Why
is-
Mithun was sacrificed?
Yeah, lordship here in like in our tribal society, if something happened, lordship, for a mutual settlement, they give a big feast, like Mithun is considered to be a sacred lord. So Mithun was, it is, yes, that it may.
No,
after-
this matter did not go to Keba.
No.
It was not before any customary court.
And your lordship, as per customary court, has no jurisdiction to try this kind of offense, your lordship.
Yes.
As per the AP code as well.
They cannot try the penal offense.
Yes, your lordship. Only some offenses are there like theft, your lordship,
Okay.
and some punishments, very, your lordship, less serious offenses.
But a settlement was reached between both the families. When this was settled? Now.
No, lordship, in way, I've made, it is pertinent to mention that the settlement documents between party was submitted to the police station as well as to the executive assistant commissioner, yes, who were,
Then it said,
but the same is not found in the report. That it was in the year 99, lordship.
and now the deed of settlement has been executed when?
It was done
In the 23rd June of 2024.
Now,
Yes.
recently also. Where, at which page?
Page number 57, your lordship.
But your averment, there is an averment that immediately after the incident also, the family members settled the matter.
Yes, your lord. That they have made the averment and there is saying that the same was produced before the
Police. also.
police station. Now at that presently they don't have the record, the document to substantiate the same.
Okay.
However, later on they have again settled this matter. Enter into a deed of settlement.
Give Kapil Gupta. This is item number 13. Heard Mr. Vijay Jamo, learned counsel for the petitioner. Also heard Mr. P. Ete, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been jointly filed by the petitioners, Mrs. Doter Sora Basar and Mr. Gangua Murtem alias Ganga Murtem praying for quashing of the criminal proceeding. What is the GR case? Which case you are going?
GR case 13 of 99.
Criminal proceeding? Namely GR case number 13/99 under section 323/354/448 slash of the Indian Penal Code. You may take your seats, both of you. Of Indian Penal Code corresponding to Naharlagun PS case number 13/1999, which is presently pending before the Court of Learned Judicial Magistrate First Class, Capital Complex, UPA. Stop. The facts relevant for consideration of the instant criminal petition, comma, in brief, comma, are as follows, comma, dash, number one, next para. On 15th of February 1999, the petitioner number 1 who was then known as Miss Doter Sora lodged an FIR before the officer in charge of Naharlagun police station, comma, inter alia, comma, alleging that the petitioner number 2 broke petitioner number 2 on the previous night, that is on 14th February 1999, at about 10:30 p.m., broke into the study room of the petitioner number 1 and attempted to where is the original FIR?
Page 14 also. The handwritten. The tab is copies 15.
Attempted to rape her and strangulate her. However, when she raised hue and cry, the petitioner number 2 escaped therefrom. Stop. On receipt of the aforesaid FIR, Naharlagun PS case number 13/1999 was registered under section 448/376/511 of the Indian Penal Code, and investigation was initiated. Stop. Ultimately, on completion of the investigation, charge sheet was laid against the petitioner number 2, bearing charge sheet number 13/1999, dated 19/4/1999. Stop. Learned counsel for the petitioner has submitted that though the charge sheet has been laid in the year 1999 itself, however, the petitioner number 2 has received summons from the trial court only. When have you received?
That is 23/4 of 2024 also.
Only in the month of April this year. Stop. It is also submitted by learned counsel for the petitioner that the both the petitioners were young at the relevant point of time and had feeling towards each other. And on the date of alleged incident, petitioner number 2, after consuming alcohol, had entered into the house of petitioner number 1. Stop. However, it is submitted by learned counsel for the petitioner that matter was amicably settled in the year 1999 itself between both the parties, including the family members of the petitioners. Stop. It is also submitted by learned counsel for the petitioner that at that time itself, the customary ritual of sacrificing Mithun was on reaching of amicable settlement between the parties was also followed, and the police was also informed regarding the settlement arrived at between the parties. So, at that time, both of you were unmarried.
Yes, Lordship, unmarried student at that point of time.
Learned counsel for the petitioner has also submitted that in the year 1990, how many years have passed?
It will be
25.
25.
In the year 1999, that is about 25 years ago, both the petitioners were students and were unmarried. However, now both of them have married and are peacefully enjoying their respective marital lives. Stop. It is also submitted by learned counsel for the petitioner that after receiving summons from the trial court in the month of April this year, both the petitioners have again met and executed a mutual deed of agreement on 23rd June 2024, a copy of which said mutual agreement is annexed as Annexure 5 along with the criminal petition. It is submitted by learned counsel for the petitioners that the petitioner number 1 does not want to pursue the criminal prosecution of petitioner number 2, and under such circumstances, it would be futile to proceed with the pending criminal case against the petitioner number 2, as the possibility of conviction in the said case, in light of the settlement reached between the parties, is very bleak. Learned counsel for the petitioner therefore submits that the criminal proceeding pending against the petitioner number 2, considering the peculiar circumstances of this case, may be quashed. Stop. On the other, no, may be quashed. Stop. In support of his submissions, learned counsel for the petitioner has cited a case, the case of, has cited the judgment of the Supreme Court of India in the case of Kapil Gupta versus State of NCT of Delhi and another, reported in 2022-0 Supreme within bracket SC 1108. On the other hand, learned additional public prosecutor Mr. T. Ete has fairly submitted that considering the fact that the alleged incident had occurred 25 years ago, as well as considering the fact that the sole eyewitness of the incident, that is the petitioner number 1, has arrived at a settlement with the petitioner number 2, and there is unlikelihood that under such circumstances the case would end in conviction of petitioner number 2. Stop. The powers under section 482 of the Code of Criminal Procedure of this court has to be invoked for securing the ends of justice and to prevent the abuse of process of court. In the instant case, when admittedly the incident occurred 25 years ago, when both the petitioners were young and were students and had feelings towards each other, and considering the fact that they have already arrived at amicable settlement between them, and the petitioner number 1 does not intend to pursue the criminal case pending against petitioner number 2, the prospect of the case ending in conviction of petitioner number 2 is very bleak. Stop. Hence, this court is of considered opinion that it would be futile to proceed with the criminal case pending against the petitioner number 2, namely GR case number 13/99, which is arising out of Naharlogun PS case number 13/99, which is presently pending before the Court of Learned Judicial Magistrate First Class, UPR. Last line, read. No, from the beginning of this line. Yes. So this court therefore allows the joint petition filed by the petitioners and quashes the proceedings of GR case number 13/99 1999 pending in the Court of Judicial Magistrate First Class, Capital Complex, UPA, against the petitioner number 2. Stop. This criminal petition is accordingly allowed.
So the two guiding factor has been reiterated in the Lakshmi Narayan case as well. Your
What it says?
Your Lordship, in para 11.3, Your Lord, Narendra Singh case has been reiterated, where in 29.2 it has been held that when party have reached the settlement and on that basis petition for quashing the criminal proceeding is filed, the guiding factor in such case would be to secure ends of justice and to prevent the abuse of process of the
Okay, that I have mentioned.
Yes.
Okay. No, I have mentioned.
Okay.
I have mentioned.
Okay.
I have not mentioned the case,
Yes,
Lakshmi Narayan case,
yes.
but principle I have.
It's already settled law, then
Okay. So this case is accordingly disposed of.
yes. Deeply obliged. Sir.
Item number 17.
Yes.
Before, my lord, take up this matter, may I mention item 20?
Yes.
This is also fixed for the Lord hearing today, final hearing. And I have seen the registry note, that the hearing note, the Lord, the respondent number 2.
Service report
service report
in
is
respect of,
still
still awaited.
Still awaited.
Yes.
Then it cannot be for hearing.
Hearing. I'm also in the item 20.
So let us pass order in item number 20 first. 20. Item number 20. Heard means Mr. M. Boj
My lord, Abhikar.
had heard Mr. Your name is Minki Boje. Minki Boje, learned amicus curiae, appearing for the appellant. Also heard Mr.
G. Tado.
G. Tado, learned additional public prosecutor. It appears from the record that though this appeal has been fixed for hearing in the cause list today, however, the service report in respect of respondent number 2, in respect of notices issued to respondent number 2, has not yet been received. We will await service or you will take fresh steps.
No, this is sharp draw without registry.
Okay. So what should we do? Should we await?
Yes, we have to
Stop. Await
Wait.
further. Let this matter be listed again after 2 weeks.
Obliged.
In this case, Mr. Pertin, you are ready. You are ready.
Yes.
Tado,
Yes.
you are ready.
Even I may try also, I will not finish.
No, I could not get you.
And I may not complete in
It may not be completed.
2 days.
Then what should we do? Because I am here for few days only. I don't want to keep matter part hurt. If you start today, if we take it again on Tuesday or Thursday, then I am ready to hear it.
Then let us fix it on this day, so that I'll continue my argument
Yes.
for 3 days or 2 days.
You will require 3 or 2 days.
But in one case I took 3 days. In one box, okay.
Okay.
Still,
I want to continue.
How much time will you require?
Actually, it is difficult to say, because once it starts, it's very difficult to stop it.
What, how many matters are remaining? This is the last matter. You are the amicus for victim. POXO is there. Rape case. Okay, let us hear it. You are ready now? then we will fix it. It is unlikely that you will complete today. We'll hear it for 1 hour today.
1 hour.
1 hour till 4 we will hear it. Then we'll take it up again on Tuesday. Tuesday we'll take it up.
Yes.
On Wednesday we'll take it up.
Well,
Wednesday we'll take it up.
Yes, absolutely.
Just a minute. Yes.
Has been
I have
prepared.
to take notes. Paper book is there, no? Your name is Mr. Ginny, S. Ginny.
G. Ginny, Lordship.
G. Ginny. Yes.
Yeah. Against the judgment order passed by the district and session judge in session case number 34, 2015. This
Yes.
judgment was pronounced on 18/1/2019. Now,
18/1/2000.
19. Yes, 18/1/2019.
Okay.
The right side of the case was there. That a commission of rape was done on 5th August 2014.
When date of
5 August 2014.
5/8/2014.
14. At around 1:30 a.m.
1:30 a.m. at night.
When the victim was sleeping with her small son. And the accused was also sleeping in the same room, but different bed.
Okay.
The victim was also a guest, and the accused was also guest.
Yes.
Yes, and they have been accommodated only in one room, but in separate bed.
Who's guest? Guest of a common host.
Guest of the common house.
Same family.
Same family.
Okay.
Then, though the allegation of offense was alleged to be done on 5th August 2014, but the FIR was launched on 28 August 2014.
28 or 9th August.
FIR.
It is 9th August. 28 or 9th?
28.
28.
But FIR shows that it is 9th of August.
Lordship, first FIR was lodged on 9th of August, Lordship.
The paper book shows that It is on 9th of August.
No, no, my lord. It was closed. This FIR was closed at 9 of August at Pasigat, at Merbo. Advised us to lodge complaint in new status. Here, they have lost the FIR at Merbo. That is in Chiang district. All in Chiang district.
Mebo at Siang district.
Yes,
But the incident occurred where?
here in Tanagar.
Okay.
And here, my lord, in the right side, left side of the FIR, it is clearly saying that complaint received on 31/8/2014.
Which FIR you are referring to?
Paperbook page 2, Your Honor.
Paperbook page 2.
Page 2. This is the second FIR. Okay. Oh, yes, yes. So next FIR was on 28.
31/8/2014.
Okay.
And registered a case by Ita Women Police Station, case number 71 of 14 under section 3761 IPC, and endorsed to SIP Kapu for investigation. Now, this is the FIR. In this case, there are two FIRs. One is paper exhibit 1 and another is paper exhibit 2. Page number 1 of the paper book is the FIR lodged by the father of the elected. My daughter, Mrs. Moontain of Bulguli, who is married to the Bon Perme of Lame village, was robbed by one Siripojirtai of Damro village, Maria, Upper Siang AP, on 5th August 2014 at 1:30 a.m. in her sleeping room at Itanagar. This case is referred late due to unknown address of the girl. Later, the address is found at Siripojirtai, son of Yakutai. WC electrician, PWD, division Pasigat. Therefore, sir, the arrest of the culprit is necessary for the satisfaction of her culprit. That is FIR 1. Then FIR 2.
By the victim.
And in the FIR 2, it is to inform you that I am a girl of around 25 years of age and married to the Bong Perme Bulguli village under my division. On August 5, 2014, when I was in Itanagar on Somgo with my village, I was raped by Cyril Bojirtai, who also happened to be residing in the same house where I stayed for the night. The incident took place at the residence of Sri P.P. Perme, Niti Bihar, who is a government servant. The offender is son of Sri Akatai, and the offense Sri Bojirtai is working as WC, Assistant Electrician, PW Division, Pakistan. Sri Bojirtai raped me while I was sleeping with my small baby around 1:30 a.m. On 5 August, I am shattered emotionally, and this crime has left a deep psychological trauma from which I cannot come out. I request you kindly to take immediate action by arresting three time. The report was lodged in Melbourne Police Station on 9 August 2020, but OC advised us to lodge the complaint in new station. Here in the FIR, the Alex incident occurred on 5th August and bomb permit reached Itanagar on 6/8/2014 from Borguli. He could have also lodged FIR if it was really committed the offense, or the wife herself could also lodge the FIR at Itanagar. But no FIR was lodged by the here at Itanagar,
By whom? By whom?
by the husband of the victim as well as the victim herself.
From where you are saying that they came to Itanagar on the next day?
On
6th.
6th, husband came on 6th Itanagar.
Is there any material to show?
Oh, yeah, he himself is the one of the witness. And report of
He stated in his testimony that he came to Itanagar.
yes.
Okay. So your submission is, as they have not filed the FIR on 6th, therefore it could not have been true.
My contention is that why the FIR was
Delay.
restart very lately. And when it was restart very lately, but they should explain the cause of the delay. But in this FIR, they have not explained anything about the cause of the delay. And when they can come to the Melbourne, why they cannot come to Itanagar?
Where is Mebo?
Melbourne is just opposite side of the Pacific, East Chang district. That district headquarters, opposite side of the Pacific. That is within the Chiang district.
Okay. In this case, whether the first FIR is not an FIR, the FIR which was lodged at Mebo,
Melbourne.
whether is it not an cannot be, whether it can be considered as first FIR?
Both the FIR have been lowered at Melbourne. Both the FIR, PXGB 1 and PXGB 2, both of the FIR was lowered at Melbourne.
No, second FIR is at Itanagar police station. Second FIR. First FIR is at Mebo. And first FIR was forwarded to Itanagar police station.
It was at Melbourne, then forwarded it to Itanagar. If it was lowered, and if it was filed at Itanagar on the same day, in that case, it will not be received on 31st/8/2014.
Okay.
Now, on the basis of this FIR, a case was registered, and they have examined 7 witnesses.
Yes.
Including the doctors and including the IO. Now, let us come to the deposition of the TW1. That is paper book page 16. This is the deposition of Move Perman, TW1, victim.
She is the victim.
I came to Itanagar on 28/7/2014, along with my husband from Borguli, Merbo, for medical treatment of my minor son. We stayed in the residence of my husband, Auntie P.P. Perme at Niti Vihar, Itanagar. It was a government quarter having 3 bedrooms. One room was occupied by P.P. Perme and her husband. Another room was occupied by their children. And the third room was for guests having 2 beds. On 4/8/2014, in the morning, my husband Bob Perme left Itanagar for Merbo. As this grandmother died at Merbo. On the same day, on 4/8/2014, in the evening at about 4:30 p.m., accused Bojir Singh came to P.P. Perme's house at Niti Vihar, Itanagar, to attend his office training at Itanagar. After dinner, accused once went to bed at about 9:30 p.m. After watching TV, I, along with my son, also went to bed for sleep. My son's age was about 11 months, and at that time, there were 2 beds in the said room. In one bed, accused was sleeping, and in another bed, I, along with my son, sleep. I kept the light on when we sleep, but later on it was found that light of the room was off. When I woke up and found accused Bojir Singh lying over me and forcing himself inside me. I tried to protest, but he penetrated his penis inside my vagina and he was doing sexual intercourse with me. I also found my panty and half pant being lowered beyond knees and shouted the accused to stop. Then somehow I put him away with my hand with force and scolded him for committing sexual intercourse without my consent. Then I took my son and went to common room with one blanket where we slept and kept awake in common room for about 1 hour and slept again and got up at about 4:30 a.m. Then I awakened Auntie P.P. Perme and her husband and narrated the incident took place in night. In the morning, when Auntie P.P. Perme and husband tried to speak with the accused about the incident, but he did not give any opportunity to them and left for training at about 7 a.m. We all were waiting for the accused to come back in the evening, but he never came back at P.P. Perme's house from training till about 9 p.m. So P.P. Perme called the accused on telephone and scolded him. During conversation between P.P. Perme and accused, the mobile kept in loud mode. So I also heard that the accused sought for pardon for his mistake. On 5/8/2014, at around 5:30, I also made call to my husband, Bom Perme, by using P.P. Perme's telephone and narrated him about the matter. On 6/8/2014, at about 2:30 p.m., Bom Perme also reached at Itanagar. On 7/8/2014, we left Itanagar and reached Borguli at about 4:30 p.m. On the same day, the accused also reached Borguli in our house and requested for settlement of the case outside and not to report the matter to the police. On 8/8/2014, my father went to PA at Melbourne to report about the matter, but the police asked my father to bring me also in the PA. So accordingly, on 9/8/2014, we went to PA and my father Tokong Time lost FIR. I have brought the copy of the FIR with me, but on 9 also, the police told us that the jurisdiction of the case falls at Itanagar, PA. So, asked us to lodge FIR at Itanagar. We were about to go to Itanagar to lodge FIR, but thereafter, suddenly there was a rain, flood started, and the Kadang Bridge of my village collapsed, and due to the transportation and communication gap, we could not reach Itanagar on time. However, after the road was opened, we went to Itanagar and lodged FIR accordingly. I was forwarded to RK Mission Hospital for medical examination. Police recorded my statement and magistrate also recorded my statement. Here given one is the FIR lodged by me and here given one is my signature. Here given two is a copy of FIR lodged by my father and 2A is his signature, 2 is I can identify. Here given 3 is the statement recorded by magistrate A and B are my signature. This is the statement made by the victim in the examination in chief. Now, cross is page 33. 33 of the Bible. It is a fact that the accused and myself slept in the same room on a different bed. When I entered the room to sleep, by that time the accused was already asleep. I do not remember if my 1-year-old child woke up or not. When I put the accused person who was attempting to rape me, here he is not telling that I was raped. Here in the court, he is telling that I was attempted to rape. I shouted for help. when the accused tried to commit rape on me. So she has shouted. That means it implies that accused has simply attempted but never committed the rape. I told the accused not to do such in the quarter where I was committed rape, where there 3 rooms. In the room, my nephew Park Perme and my niece Nunun Perme were sleeping, and in the another room, the owner of the quarter, Onil Sina and P.P. Perme were sleeping. Just near to their room, the owners, the house owners, daughters and so on are sleeping near to that, and the husband and wife also sleeping near to the adjacent to the room. All the 3 rooms were situated nearby. The quarter was L-type and type 1. The FIR was drafted by my father, who studied up to class 12. I knew the accused prior to the incident. The accused is my clan brother, and as he is also time father, his wife and my husband are of Perme clan. Here in the court, he has not stated that he has been raped. Then come to the statement of PW2. The deposition of Bom Perme.
Page,
PW2 is about
Page 19.
Page 19. Now,
page 19 or 20? Page 20.
yeah. Page 20. Accused Bujurtang is my brother-in-law, and he is a clan brother of my victim wife. On 28/7/2014, I, along with my wife and son, went to Itanawal and were getting treatment of my son. We stayed in my Auntie Pipia Perme's house at Nitivia, Itanawal. On 3rd and 4th August 2014, I left for Borivali as my mother asked me to come as my grandmother died. On the next day, I received a telephonic call from my wife informing me that accused Bojitang has committed sexual intercourse with her without her consent. Then I again went back to Itanawal, where my wife narrated me about the incident of sexual intercourse by the accused, and after 2-3 days, e.g., on 7/8/2014, we again left Itanawal for Borivali village. On 8/8/2014, my father-in-law and myself went to Merbo PL to lodge complaint against accused, but police asked us to come on 9/8/2014 along with PP. So accordingly, on 9/8/2014, we went to Merbo PL again, where the police told us that we had to lodge complaint at Itanawal, where the incident took place. When we were preparing to go to Itanawal, the southern bridge of my village collapsed due to rain and flood, because to which we could not come to Itanawal immediately. However, later on, after opening the road, we went to Itanawal and my wife lodged complaint against accused. Police has reported my step. As a cross. My grandmother was buried on 3/8/2014, and the funeral was conducted on the same day. Above statements are recorded by me under the dictation and directions of the presiding judge. So this is the only clause. The bond payment statement, though it been recorded, but he was not the person who was present at the station, and he had stated only on the statement given by his wife. So, yeah, this statement is here's the evidence. Now, come to the PW3, TP permit. I know the page 22. I know the accused person by name on 4/8/2014. At about 5:07 p.m., the accused person came to my house at Niti Vihar. During that time, the alleged victim woman was also staying at my residence as my guest. As I have a small type 1/4, so I accommodated both the accused and the alleged victim woman in the same room by providing them separate beds. On the next morning, the alleged victim woman told me that at the night hour, the accused person claimed on her. On the next day, I wanted to call the accused person for having mischief with my daughter-in. The victim lady, however, the accused left my house early. Later, I scolded the accused about 4. Here, in the before the period 3, he had not said that the victim was raped. In front of her, the only use misbehave. Misbehave cannot be interpreted as a rape, and rape cannot be interpreted as a misbehave. So here the committee of rape, he has not mentioned anything. So it is a fact that when I call up it accused person in the evening, on 5th August over telephone, the accused stated that he had committed the mistake. The room where the accused and the victim women are accommodated and our room are separated by a wall. In the night hours, I did not hear any noise of quarrel or screaming. Also, did not hear the crying of child. I do not know if the accused and alleged victim only are related to it as brother and sister. So, according to the statement of the victim, she has stated to the PW3, but PW3 never said that she was committed rape. And since really anything was occurred in that case, if any sound is made, it would be hard